Welcome to jury charge and literary practice. Let's get started with some jury charge. Ready? A reasonable doubt may rise not only from the evidence introduced, but also from a lack of evidence, since the burden is always upon the government to prove the defendant guilty beyond a reasonable doubt of every important element of the crime charged. There are two types of evidence from which you may determine the truth as to the facts in any given case. One is direct evidence, and the other is circumstantial evidence. Direct evidence is the testimony of one who states he has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either type of evidence. You should weigh all the evidence in the case. After weighing all the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find him not guilty. You, as jurors, are the sole judges of the credibility of the witnesses. In other words, you alone are to determine whether to believe any witness. If there is any conflict in the testimony, it is your function to resolve that conflict and to determine just where the truth is. You should give the testimony of each witness such weight as in your judgment it is fairly entitled to receive. Now, ladies and gentlemen, the weight of the evidence is not necessarily determined by the number of witnesses testifying on either side. You should consider all of the facts and circumstances in evidence to determine which witnesses are worthy of belief. All right, now let's get back to our article about posting on social media. Okay, ready? A few moments of reflection is especially important for students who are making connections with potential employers. Put yourself in the employer's shoes before commenting, liking, or sharing on social media, said Natalie Kijerna, coordinator of graduate and employer relations at College of Court Reporting in Hobart, Indiana. Would you hire someone who liked the comment, "The last 12 minutes in the restroom were the most productive part of my work day"? Probably not. Students who are interested in captioning especially should consider the accessibility of their content. I think it's a huge disrespect to clients to post and retweet videos and media without captions. said Mirabelle Knight, RDR, CRC, a cart captioner from New York, New York. Proofread. Despite the popularity of text speak, court reporters and captioners should make sure to use more proper English in their posts. I know of individuals who were not given jobs based solely off of their punctuation and grammar online, said Benoit. As petty as that may sound, would we hire a scopist or proofreader who didn't have good punctuation or grammar? No. I have to say that one's a big one with me. It's kind of crazy. It seems like, in my opinion, more and more people just aren't proofreading. They aren't using punctuation, not capitalizing people's names. It really makes me crazy. So it's very interesting that could actually, it sounds like it's actually has cost people a job, because they're so relaxed, I guess, with all that on social media, but since it's seen by everyone, it can cause problems. It's definitely food for thought. All right, let's get back to our jury charge practice. This jury charge, maybe pick out some of the words, bring to your attention ahead of time. Constitution, constitutional, punishment, Miranda decision, Miranda rights, Supreme Court, bondsman. The court acts as the bondsman, like posting bail. So bondsman is, just so you know, is one word, BONDSMAN. And we have bench warrant. Okay, let's give this one a try. There was no question but that his rights were read. Particularly, the question that was raised was whether the defendant has wiretaps on his phone. Wiretaps are not legal in the state. After his rights are read, the suspect is allowed to have an attorney represent him in court. The police are trained to inform the suspect that he has certain rights that are granted to him or her according to the Constitution of the United States. These constitutional rights are important to the individual as he proceeds to trial. The Constitution provides that there are a number of rights that the person has before, during, and after the trial. A person is not to be arrested without cause. There must be a reason for the arrest. The cause is referred to as probable cause. Probable cause means that the person probably committed the crime. There is enough evidence to say that he probably did it. After the person is arrested, the person has the right to remain silent and to be represented by an attorney. At trial, the person is to have the right to be heard in front of a jury of his peers. After the trial, he has a right to receive a just punishment. A just punishment, where murder is concerned, may involve the death penalty. In this case, the defendant would have been subjected to the death penalty had he been found guilty. The right to a speedy and public trial and jury is an important right. In some places, that right is not granted. Another right is the right to confront witnesses. The person has the right to hear the witness in court and to respond. The first time that he is allowed to appear is called the initial appearance. Before a person is questioned, the person is supposed to be informed of his rights. An important case decision is the Miranda decision that sets forth the principle that a person must be informed of his rights. The rights that a person is to be informed of is his right to an attorney and his right to remain silent. The officer or officers who are taking the person in for questioning must inform the suspect that he has the right to an attorney and the right to remain silent. These rights have been set forth for him in the Constitution. However, it is the Miranda decision that requires that the person be informed of these rights. There was no question, but the police read the Miranda rights to the defendant. The question was whether there was a wiretap placed on the phone of the defendant. The Miranda warning tells you that you have the right to remain silent and the right to an attorney. These two rights are so important that a Supreme Court ruling determined that police must tell the arrested party of their constitutional rights. A judge can also require that a gag order be issued to keep information about the trial from getting released. A defendant must post bail to be released from jail and will lose that money if he or she fails to appear in court. A bondsman will, for a certain percent of the bail, act as the surety and post the money. In states where there is no bondsman, the court acts as the bondsman. This means that the defendant must pay the court the bail. If you are released on your own recognizance, you need not pay anything. The judge would not release the individual on his own recognizance, nor would he allow the defendant to post bail. He was not convicted, Convinced that the defendant would be available for his court appearances, the judge should issue a bench warrant if he failed to appear in court. All right, I hope that went well for everyone. So let's get back to our literary practice, the magazine article we're reading on social media. All right, this section in particular is on positivity. Here we go. It's obvious from any comments section online, people can be unkind on the internet. It still astounds me when I see inappropriate or just nasty posts online, said Schilling. Some students think that the screen protects them from the consequences of their actions online, which will only result in a rude awakening down the line. However, part of being a professional involves responding to others politely and compassionately. A lot of people ask for help and people criticize them for that, said Angie Starbuck, RDR, CRC, a freelance reporter in Columbus, Ohio. We should help them out, not tear them down. After all, everyone needs help sometimes. A student who has already presented themselves as a professional will more likely be treated as one by others. Provocativeness. Even though many profiles are created for personal reasons, developing a more professional profile often means avoiding certain kinds of content. Students should stay away from negative commentary about current or former employers, politics, religion, or anything that could potentially reflect poorly on your character. Let's see what provocativeness. That's a word to practice. Positivity. That's another one. All right, we'll read more in a bit. Let's get back to our jury charge practice. Ready? Both of the defendants have taken the stand as a witness in their own behalf. With reference to such testimony, the court instructs you that the defendants have a right to become witnesses in their own behalf. Their testimony should not be disbelieved just because these witnesses are the defendants. In weighing their testimony, however, you may consider the fact that the defendants have a vital interest in the outcome of the trial. You should give their testimony such weight as in your judgment it is entitled to receive. Ladies and gentlemen, as the court earlier indicated to you, there are 2 defendants on trial. Each defendant is entitled to have his guilt or innocence as to the crime charged determined from his own conduct and from the evidence which applies to him as if he were being tried alone. You may find any one or more of the defendants guilty or not guilty at any time during your deliberations. You may return your verdict of guilty or not guilty with respect to any defendant. In the crime of robbery with which these defendants are jointly charged in the indictment, the state must prove beyond a reasonable doubt that the defendant took property of some value from the owner against the will of the owner. After having carried it away, took such property without the right to do so, and with the specific intent to steal it. All right, let's see if there were any words in there that we might want to spend some time on. Innocence, deliberations, all right, that will conclude our literary and jury charge practice for today. Thank you.